Get ready. 3 seconds. 2 seconds. Start. This appeal has been preferred against the judgment and order of the Gauhati High Court dated 20/2/2004, passed in Criminal Appeal number 188 of 2003, by which the appeal against the judgment and order of Sessions Court Kamrup Gauhati in Sessions case number 87 (K) /97 (GR) case number 47 of 1995 has dismissed, wherein the appellant was convicted under section 376 of the Penal Code 1860 and sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 2000, in default to undergo imprisonment for another 6 months. However, the High Court reduced the sentence to 4 years and fine to rupees 1000. The facts and circumstances giving rise to this case are that the appellant allegedly abducted a minor girl, namely X, on 7/1/1995, took her to a hotel and committed rape on her. The victim, PW4, was working as a maidservant in the house of PW2 and his wife, PW3, under Paltan Bazar Police Station, Guwahati. The appellant was a security guard in the house of that locality. The appellant and the prosecutrix knew each other from before. According to the prosecution, on 7/1/1995, PW4, without informing her employer, PW2 and PW3, went to see the zoo with one who was known to her. While they were coming back from the zoo, they met the appellant near Ulubadi Chowk. The appellant, on the pretext of taking the prosecutrix, PW4, to the police station, took her to hotel situated at Paltan Bazar. In the hotel, he hired a room in fictitious names and kept her in the room for the whole night and committed rape on her 3 times. On the next morning, he sent her in a rickshaw. PW4 came to the house of a person and telephonically informed her employers about the incident. PW2 brought her to his house and she narrated the whole incident before him. The written FIR relating to the incident was lodged by PW2. In the morning of 8/1/1995, the police registered the FIR and investigation was conducted by PW7, Sub-Inspector of Police. During investigation, he got the prosecutrix medically examined in GMCH by PW1. The statement of the prosecutrix was recorded by PW5, Judicial Magistrate First Class, Guwahati, under Section 164 of the Criminal Procedure Code. After completion of the investigation, PW7 submitted charge sheet against the accused under Sections 366, 342, 376 IPC. On committal of the case to the Court of Session, charges under Section 366/376 IPC were framed against the appellant. The appellant pleaded not guilty to the charge and hence the trial commenced. During the trial, the prosecution examined 7 witnesses, including the investigating officer. The trial court found the appellant guilty of the offense punishable under Section 376 IPC and sentenced him to undergo rigorous imprisonment for 10 years and to pay a fine of Rs 2,000, in default to undergo imprisonment for another 6 months. Being aggrieved, the appellant preferred the appeal before the High Court. The High Court upheld the conviction under Section 376 IPC but reduced the sentence to a period of 4 years and to pay a fine of Rs 1,000, in default to further imprisonment for 1 month. Hence this appeal.